On a recent Saturday, the Trump administration submitted a motion in court asserting that the government should not be obligated to provide basic due process to immigrants. They argued that even speaking to these individuals, even determining which country they should be deported to, would impose too much of a burden on the system. This burden they referred to, however, is nothing less than a foundational principle of American democracy. The Constitution of the United States, specifically the clause guaranteeing due process for all individuals within the country's borders. The administration presented this argument to a judge who had already made clear that the government could not simply deport people to countries they are not from. Nevertheless, the administration contended that engaging in conversations with these individuals, asking them questions, hearing their concerns, understanding where they might face danger if deported, was simply too much of a hassle. But that hassle is not optional. It is a constitutional requirement. Regardless of citizenship status, anyone apprehended on U.S. soil is afforded the protections enshrined in the Constitution. This includes the right to due process, the right to be heard, and the right to fair treatment under the law. That's the rule of law. It's what distinguishes a democracy from an autocracy. Yet the administration's motion in court amounted to a rejection of that principle, essentially suggesting that constitutional protections can be brushed aside when inconvenient. The Department of Justice's argument was published in full as part of their legal challenge to a ruling by District Judge Brian Murphy. His order had blocked the Trump administration from deporting immigrants to so-called third countries, places they had no connection to. According to the DOJ, this order forced the Department of Homeland Security to not only retain custody of these individuals, but also to engage in private interviews to determine whether they had reasonable fears about being deported to certain countries. The DOJ painted this not as a necessary step to protect human rights, but as an unwelcome administrative load. They expressed dismay at the idea of having to ask detainees if they feared persecution. They resented being required to conduct these interviews privately and at times convenient for the detainees. The tone of the administration's motion reflected not just bureaucratic frustration, but something more dangerous: a disdain for the legal frameworks that are supposed to guide government action. The underlying sentiment was unmistakable. These people don't matter enough to warrant the protections the Constitution promises. This pushback against due process is not merely a legal quibble. It signals a desire to reshape the structure of power in the country. The rhetoric and legal arguments show a preference for centralized authority, where executive power overrides individual rights, where orders can be issued unilaterally, and where people can be disappeared quietly into distant corners of the world, perhaps never to be seen or heard from again. That is not a system based on laws. That is something else entirely. To make matters even more absurd, Secretary of State Marco Rubio weighed in on the matter, filing a declaration in court. His statement, later posted to Twitter by DOJ Chief of Staff Chad Zell, claimed that the court's orders were inflicting significant and irreparable harm on U.S. foreign policy. According to Rubio, requiring due process was undermining strategic relations with countries like Libya, South Sudan, and Djibouti. The implication was that respecting the constitutional rights of detainees could jeopardize America's diplomatic objectives in these nations. It's a strange priority. The administration, at a time when it was alienating traditional allies like the European Union, seemed determined to curry favor with governments in unstable or hostile regions. And the reason? So they could continue to ship detainees there, regardless of the risks those individuals might face. The sheer incoherence of this strategy is matched only by its cruelty. What's clearer than ever is that this wasn't just about immigration. It wasn't even about national security or foreign policy. It was about redefining what the US government believes it can get away with. The fact that officials could stand in court and label constitutional adherence a burden should be deeply alarming. It reveals an administration that sees the law not as a guidepost, but as an obstacle. And if that fundamental shift in thinking doesn't raise concern, then it may be that we've lost sight of the very principles that hold this country together.